Acceptance, not accepted, acceptance, present tense. Acceptance, 34. 1. The acceptance of a bill of exchange, is the signification by the drawee of his assent to the order of the drawer. The drawee is always the one that is making the tender. I stray away from using the word payment because in a court case during a foreclosure, everything was going really good until the gentleman said, "Your Honor, I've made those payments." And he said, "If you use that language again in this court, I'll have you escorted out of here." Everybody was looking around at each other like, did he say a bad word? Was he cussing? No. He made the fatal mistake of saying that he had made payments, that he had paid it off, that he was paying. And it's an impossibility to pay after 1933. You cannot pay anything. You can only tender, set off, and discharge. That's it. All right? So 34, acceptance, not accepted, acceptance, present tense. The acceptance of a bill of exchange is the signification by the drawee, the tenderer, of his assent to the order of the drawer. Now, it's important to understand that your juristic person is the one that is making the tender. All right, you're merely the agent. Okay, you're the beneficiary of the decedent estate that has a Social Security account, that has an estate, that is, in fact, a trust. Okay, and all these persons that are out there belong to your estate, belong to your trust. It's already functional, it's already up and running. It's a matter of you learning how to utilize it. Okay, and understanding the difference between you and it. Had a prosecuting attorney one time hold up a driver's license while I was in court, and he says, "Is this you?" And I said, "No, dumbass, it's a piece of fucking plastic. I'm me, and that, well, for all intents and purposes, is an inanimate object with a decapitated image and some very, very loud letters on it, okay? It's a piece of plastic." And everybody in the court started laughing because the point that I was making was too fucking relevant, all right? So that's a piece of plastic. And that piece of plastic belongs to the estate, which belongs to the state, which belongs to the United States. And I merely am a beneficiary. I have the use of it. Okay? So you have to be able to start distinguishing the difference between yourself as a man or a woman, having a sentient being and soul, mind, body, spirit, and soul. All right. And even this will grab you by your short and curlies, because I'm going to tell you, your body doesn't even fucking belong to you. It is merely a vessel. From the dirt it came, and the dirt it shall return, but your spirit will forever eternally live on. Okay? So your essence, your soul, your life source energy is trapped in a meat sack right now that doesn't even belong to you. It's part of the estate as well. Okay? Important to know these things. And you are merely have the beneficial use of it, okay? So when we're doing these acceptances, we're doing it as the agent on behalf of the estate or trust, okay? The Sestake trust, however you want to look at it. We have the right of use of the account, okay? So the drawee, the one who's making the tender, is actually the Social Security person. That's the account that it's coming out of. So why would we argue with these people? Just give them what they want. Give them what they want. Make your life easy. Go ahead and endorse it as an agent, okay? As the beneficiary, if you like. I like agent myself, and I'll show you why in the UCC why I use agent. But acceptance. The acceptance of a bill is the signification by the drawee of his assent to the order of the drawer. Not a problem. Why? Because the drawer is one of our persons at a financial institution, okay? We have securities intermediaries. We have trustees that are drawing up these instruments, these payment vouchers, and they're sending them over to us over here. And it's like playing tennis. They volley the ball from here, send it over to here, and we turn around and send it right back. Done. Okay? With some endorsements, a stamp on it, put it in the mail. Phew, c'est la vie, right? And we want to do that in 3 business days if we can. Sometimes we can't get to it that quick. Lord knows we all have things in our life that cause us not to get the mail as frequently as we should, whatever, day in and day out. But do your best to stay on top of your business. Have you ever heard this growing up? Mind your own business. Ladies and gentlemen, that's what I'm teaching you. I'm teaching you how to mind your own fucking business. And life will be really good if you take good notes, okay? There's another one out there, another saying, you know, that I used to hear as a young lad. It said, get out there and make a name for yourself. Well, I got news for you. That saying, it has a lot of weight and merit because you're not in the book of life yet, okay? And you need to be. And we'll talk about that another time as well. Drawee's name wrong. 2, where in a bill, the bill of exchange, the drawee is wrongly designated on his name or his name is misspelt, he may accept the bill as therein described, adding, if he thinks fit, the proper signature, or he may accept by his proper signature. Okay, so you don't have to correct him necessarily, although it'd probably be a good idea to get rid of the confusion because as an administrator, you're going to find that you're going to fill many roles, many hats. And as an administrator, we give orders, we correct records, okay? We make sure that what needs to be done shall be done. We follow the principles of equity. Acceptance, not accepted like everybody's telling you, accepted for value. It's acceptance. 35.1, an acceptance is invalid unless it complies with the following conditions. You might want to pull your head out of your ass because we're getting ready to tell you exactly how this works. Not how Derek conjecturally feels how it should work, but how the law is written, ladies and gentlemen. A, it must be written on the bill of exchange and be signed by the drawee. And B, it must not express that the drawee will perform his promise by any other means than the payment of money. All right? Well, what is the payment of money? Under the 73rd Congress, March 6, 1933, the new definition under the new law for money is notes, drafts, bills of exchange, banker's acceptance, trade acceptances, okay, that are then lent to the bankers who take them to any Federal Reserve agent or Federal Reserve discount window and give them to the comptroller of the currency or the treasury, and they review them, and then they issue United States obligations, which are Federal Reserve notes, back to the bank, which are the obligations of the United States. Okay? That's how that system works. I didn't come up with it. That's what Congress says. All right? Mere signature, the mere signature of the drawee written on the bill without additional words is sufficient for an acceptance. All right? Just the mere signature of the drawee written on the bill without additional words is sufficient acceptance. But here's the thing. We want to make sure that we don't have any liability that comes back to us. How are we going to do that? Well, ladies and gentlemen, we're going to put on there for collection, given for a patent right, done in good faith, without recourse. Okay? Real simple shit. Acceptance, done in good faith, given for a patent right, for collection, without recourse. By, full colon, last name, comma, first middle, /agent, right thumbprint, boom, done. All right. Pay to the order of. All right. Or pay to the bearer. And then you're going to write it out just like you would on a check. You're going to write it out numerically. You're going to use the alphabet and spell it all out alphabetically. And then you're also going to write the numbers out just like you would a check. Acceptance. 36. A bill of exchange may be accepted before it has been signed by the drawer or while otherwise incomplete, or B, when it is overdue or after it has been dishonored by a previous refusal to accept or by non-payment. Acceptance. A bill of exchange may be accepted before it has been signed by the drawer or while otherwise incomplete, or B, when it is overdue or after it has been dishonored by a previous refusal to accept or by non-payment. Acceptance after dishonor. When a bill payable at sight, that's what they call a sight draft, or after sight is dishonored by non-acceptance and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill of exchange accepted as of the date of first presentment to the drawee for acceptance. All right? Kinds. 37.1. An acceptance is either general or qualified. All right? General. 2. A general acceptance assents without qualification to the order or the drawer, to the order of the drawer. Qualified. A qualified acceptance is in express terms varies the effect of the bill of exchange as drawn, and in particular, an acceptance is qualified that is conditional, that is to say, that makes payment by the acceptor dependent on the fulfillment of a condition therein stated. B, partial, that is to say, an acceptance to pay part only of the amount for which the bill is drawn. C, qualified as to time, or D, the acceptance of one or more of the drawees, but not of all. I don't know why you would want to pump or dink around with any of this shit. All right, just settle it. All right, right out the gate, do a general acceptance and be done with it. Unless you've got some special terms where the financial institution's not meeting your needs, and you're saying, hey, look, I'll endorse part of this, but I'm not going to endorse the rest until you uphold your end of the bargain type of deal. But I don't think you'll ever have to do that if you start executing these processes properly. Specified place. 4. An acceptance to pay at a particular specified place is not on the account conditional or qualified. Delivery. When acceptance complete. 38. Every contract on a bill of exchange, whether it is the drawers, the acceptors, or an endorser's, is incomplete and revocable until delivery of the instrument in order to give effect thereto. But where an acceptance is written on a bill of exchange and the drawee gives notice to, or according to the directions of the person entitled to the bill, that he has accepted it, the acceptance then becomes complete and irrevocable. Tender has been satisfied, all right, by doing an acceptance, and they don't accept it, ladies and gentlemen. They fall into dishonor. And then you go over to the district attorney and you let them know that they're in dishonor. You made a copy before you put it in the mail. You filled out everything properly. You endorsed it properly. You sent it back to them, and they're in dishonor, and that's criminal, okay? You're a creditor of the United States. You have special drawing rights, ladies and gentlemen, and you have the ability to follow the letter of the law, negotiate these instruments, these bills of exchange, endorse them properly, and send them back for full tender, set off, and discharge. All right. Requisites 39.1. As between immediate parties and as regards a remote party, other than a holder in due course, the delivery of a bill of exchange, A, in order to be effectual, must be made either by or under the authority of the party drawing, accepting, or endorsing, as the case may be, or B, may be shown to have been conditional or for a special purpose only, and not for the purposes of transferring the property in the bill of exchange. Presumption 2. Where the bill of exchange is in the hands of the holder in due course, a valid delivery of the bill of exchange by all parties prior to him, so as to make them liable to him, is conclusively presumed. All right. When you're executing this properly, the rest of the parties now conclusively are presumed to be liable to you. Okay. Because if they don't honor this instrument at this point, they don't follow the law, ladies and gentlemen. Okay. You've been caused harm, damage, and loss, not only to your reputation if they reported it at some credit bureau, if you will, but what if your electricity gets shut off? What if your water gets shut off? Now they're causing you harm, damage, and loss. All right. Remember, ignorance of the law excuses no one. All right. For all people, all businesses, all corporations are responsible for knowing the laws they enter into. Parting with possessions. 40. Where a bill of exchange is no longer in the possession of a party who has signed it as drawer, acceptor, or endorser, a valid and unconditional delivery by him is presumed until the contrary is proved. This is why you want to use your 3811s. Okay, you want to send it out either certified mail, registered mail, or there's another option that's far cheaper, certificate of mailing. Okay, it costs nothing to do a certificate of mailing. I think it's $1.36 or $1.63. It's super fucking cheap. And in a court of law, a certificate of mailing, from the day that the postmaster stamps off on that certificate of mailing, it is considered served. All right. Computation of time, non-judicial days, and days of grace. Computation of time, 41. Where a bill is not payable on demand, 3 days called days of grace. This is equity right here. Anytime you see the word grace, that's equity. Are, in every case, where the bill itself does not otherwise provide, added to the time of payment as fixed by the bill, and the bill is due and payable on the last day of grace. But whenever the last day of grace falls on a legal holiday or non-judicial day in the province where any such bill is payable, the day next following, not being a legal holiday or non-judicial day in that province, is the last day of grace. All right. So grace is an equitable term. The other reason they do 3 days grace is because typically in the mail, it takes about 3 days to get your mail anywhere within the state. It takes about 72 hours. Some are quicker than others. But again, they give 3 days grace. And if you're responding to these vouchers, these coupons right away when you get them, you got more than enough time, because they typically allow you up to 9 days in some of the shorter ones that I've seen, and up to as much as 30 days from some of the longer stipulations of time that I've seen on these coupons and vouchers. Okay. Remember, coupons and vouchers, they're just as good as money, because under Title 18, subsection 8, all obligations are obligations of the United States. Notes, drafts, bills of exchange, bankers' acceptance, trade acceptances, vouchers, coupons. We'll go through it a little bit later. You'll see what I'm talking about. Non-judicial days, 42. In all matters relating to bills of exchange, the following and no other days shall be observed as legal holidays or non-judicial days. In all the provinces, Sunday, New Year's Day, Good Friday, Victoria Day, Canada Day, Labor Day, National Day for Truth, and Reconciliation, which is observed on September 30th, Remembrance Day, and Christmas Day. You got to throw in them pagan holidays. 2. The birthday or the day fixed by proclamation for the celebration of the birthday of the reigning sovereign. Well, fuck. That's every day. 3. Any day appointed by proclamation to be observed as a public holiday or as a day of general prayer or mourning or day of public rejoicing or thanksgiving throughout Canada. And 4. The day next following New Year's Day, Christmas Day, and the birthday of the reigning sovereign, if no other day is fixed by proclamation for the celebration of the birthday, when those days respectively fall on a Sunday. B. In any province, any day appointed by proclamation on the lieutenant governor of the province to be observed as a public holiday or for a fast or thanksgiving within the province, and any day that in a non-judicial day by virtue of an act of the legislature of the province. And C. In any city, town, municipality, or other organized district, any day appointed to be observed as a civic holiday by resolution of the council or other authority charged with the administration of the civil or municipal affairs of the city, town, municipality, or district. Time of payment, 43. Where a bill is payable at sight or at a fixed period after date, after sight, or after the happening of a specified event, the time of payment is determined by excluding the day from which the time is to begin to run and by excluding the day of payment. Sight bill or sight draft, sight bill of exchange, sight draft. Where a bill is payable at sight or at a fixed period after sight, the time begins to run from the date of the acceptance if the bill is accepted, and from the date of noting or protest if the bill is noted or protested for non-acceptance or for non-delivery. Due date, 45.1. Every bill that is made payable at a month or months after date become due on the same number day of the month in which it is made payable as the day on which it is dated, unless there is no such day in the month in which it is made payable, in which case it becomes due on the last day of that month, with the addition in all cases of the 3 days grace. All right. Definition of month. The term month in a bill of exchange means the calendar month. Capacity and authority of parties. Capacity of parties, 46.1. Capacity to incur liability as a party to a bill is coextensive with capacity to contract. Corporations, 2. Nothing in this section enables a corporation to make itself liable as drawer, acceptor, or endorser of a bill of exchange unless it may do so under the law in force relating to that corporation. Effect of disability on holder, 47. Where a bill is drawn or endorsed by any infant, minor, or corporation having no capacity or power to incur liability on a bill, the drawing or endorsement entitles the holder to receive payment of the bill and to enforce it against any other party thereto. Forgery. This is one of my favorite ones. This is what the bank's doing during a foreclosure. They're bringing in a forgery. All right? 48.1. Subject to this act, where a signature on a bill is forged or placed thereon without the authority of the person whose signature it purports to be, the forged or unauthorized signature is wholly inoperative, and no right to retain the bill of exchange or to give a discharge thereof or to enforce payment thereof against any party thereto can be acquired through or under that signature, unless the party against whom it is sought to retain or enforce payment of the bill of exchange is precluded from setting up the forgery or want of authority. This in the United States is known as Federal Rules of Evidence 1002, ladies and gentlemen. You have the right to inspect the original, all right? You have the right to inspect the original under Federal Rules of Evidence 1002. Ratification. 2. Nothing in this section affects the ratification of an unauthorized signature not amounting to a forgery. Recovery of amount paid on forged checks. 3. Where a check payable to order is paid by the drawee on a forged endorsement out of the funds of the drawer, or is so paid and charged to his account, the drawer has no right of action against the drawee for the recovery of the amount so paid, nor any defense to any claim made by the drawee for the amount so paid, as the case may be, unless he gives notice in writing of the forgery to the drawee within 1 year after he has acquired notice of the forgery. Default of notice. 4. In case of failure by the drawer to give notice of the forgery within the period referred to in subsection 3, the check shall be held to have been paid in due course with respect to every other party thereto or named therein, who has not previously instituted proceedings for the protection of his rights. When we come back, we'll be delving into, we just covered delivery. I think we covered that as well. Computation. We sure did. Moving right along. I think we covered capacity, didn't we? We covered that as well. So when we come back, we'll be talking about the holder in due course blues, ladies and gentlemen. The holder in due course blues. All right. So thank you for joining me. When we come back, we'll be talking about the holder in due course blues.